YouTube, so that you can just, my account name is Theophilus Sosi on YouTube. And so you can join us there. I am deeply sorry about this. This is pretty disappointing. So yes, without further ado, and I'll be telling you a lot of things because we put out a Google link for a lot of you to also fill. There were interesting revelations in there. Some of you had interesting questions out there. The one that there was one particular message that really struck me, you know, and that the person, I mean, no names were required. Somebody put out there the everything seems to be moving so fast. That was somebody's challenge. And I think it's something that, well, personally, I can also associate with, because we seem to be doing so many things and everything seems to be doing so fast. And so I'd like to invite our resource person and speaker, Jonathan Alua, to tell us some things that he wished he knew before the Part 1 exams. And then we'll be engaging with some of your questions right here on the platform and the ones that you sent us earlier. Thank you so much. Jonathan, the platform is yours.
Hi guys, good evening. I hope you're all well. Law school can be stressful, so I can understand when exam time approaches, people begin to panic. But first and foremost, I really think that we should pay more attention to our mental health, because you might have all the substance and all, you know, but one very tiny mental breakdown can, you know, jeopardize your entire exam. So it's I think it's very important that we pay attention to our emotional and psychological state of mind going into exams. That's just, you know, for starters. I agree to do this naturally because, yes, my experience with law school was Part 1 particularly was a little harder than Part 2, because in Part 1, I would say I wasn't, I didn't immerse myself as much as I did in Part 2. And that's partly because, as he said, I was running for office. But you know how it is. The first reason why you go to law school is to become a lawyer. So that always, you know, has number one spot on my list. So I needed to find a way to make it happen. And I did find a way to make it happen. So, I have lessons, I have experiences, and I'd love to share. So when I put out the flyer, you know, trying to exhort people to show up, somebody texted me and said, am I an expert in Part 1 exams? And then, you know, I was just, it was a hysterical comment. I laughed at it. And then I said, you know, nobody's ever an expert. If you write Part 1 exams more than once, that doesn't make you an expert, does it? It only means that you need to do a lot more work to scale that hurdle. So it's really just about sharing experiences. I don't come here waving a magic wand that's obviously going to ensure success for everybody. But I can assure you that my personal experience might be helpful. Definitely should be helpful to all of you in your march towards the bar. Having said that, by way of introductory remarks, let's just dive straight into business, because somebody said everything is moving so fast. We don't have time on our hands. It's a fast-paced world, and legal education is equally fast-paced too. So, thing about law school is we're all coming from faculties where obviously if we didn't do well, we wouldn't be in the law school. You need to pass and obtain an LLB before you can transition into Makola. You know, it doesn't matter if you came in with a first class or an upper or even a lower. You earned the degree. You were awarded a degree, and then you walked into law school on merit. So on that score, I think everybody's well equipped to take this program and excel at it. The thing, however, is sometimes we walk into Makola and we are still stuck in the past. You know, we don't pinch ourselves to the reality of the fact that it's a professional law school, and, you know, the requirements are different. The training is a little different, you know, and all boils down to the exam, which really is pivotal in all of this. That too is very different from the exams at the faculty. So yeah, if I could turn back the hands of time, of course I wouldn't want to do that, because who wants to go back to law school with all the stress? But for the sake of the expression, to have armed myself with all the information I'm going to give you now, of course, what I would have done would have been to give ample time to all the courses And I must give credit to Nicholas Opoku. You know, I mean, when I was preparing to come and talk about this, he shared with me something he put out.
Jonathan.
Yeah.
Jonathan, I'm really sorry. Let me resolve this issue in 10 minutes because I mean, I'm receiving lots of messages. I mean, quite a number of people can join. I am very, very surprised about this development because this matter was sorted out. And so, and I mean, you've already started saying some really important stuff. So can we deal with this matter in 10 minutes so that we find a way to do it? I hope you don't mind.
All right, sure. I'm on standby.
Yes. Okay. So this is interesting, but there's a gentleman who messaged me about having a platform that could accommodate a lot more of us. Carl Williams, because yes, we are streaming on YouTube, and so, but we've passed that message around, and I'm not too sure that would get to a lot of people. So, Carl, if there's a way you can we can communicate so that we can reconvene. So I'm very sorry, I may have to end this session. I don't know what the prospects of that would be, but we may have to end the session and then reconvene on another platform. The link will be put out so that more and more people can join the platform. Someone also recommend that we should just record and then share the recording. Okay, then I guess Jonathan, I guess we can just continue.
Did you say I should go ahead?
Yes, I think we should go ahead.
Okay, cool. So part one, well, 6 courses, 2 boxed into 1, so 7, but really 6, right? In my time in law school, before I took the part 1 exam, I kind of felt like ADR was a pushover, so I'd leave some of those courses that I thought I could like study in one night. Of course, coming from the faculty, you know, I remember Legon, LLB, PI, or those who know me know that's just about the only law course I dislike. So that course, for instance, I studied in one night, and only God knows how I passed it. So I was like, yeah, I'm going to leave ADR and the likes of LPM, ADR, accountancy. I'll leave those, for later because they don't seem like they're too technical. And then I'll focus on those like evidence, which seems to be bulky, like criminal procedure, which obviously is something I love, and like civil procedure, which is like the fulcrum of civil law and civil practice, So I'm like, you know what, these are those that deserve your attention and your time because the rest of them don't seem that complicated. Guess what? I was wrong. The thing is, you remember classification, right? Right from year 1, legal systems and methods. Remember that the primary reason why we classify law into brackets is convenience, really. Because if you look at it technically, adjectival and substantive law, procedural law, as you'd call it, the only reason why we create the distinction really is for convenience. When you lump all of the law together, it's supposed to work together like a snowball, right? That's so powerful that it should be able to vindicate people's rights and, grant people liberty and all of that. So there's really only convenience as a driving force for classifying law into civil procedure. And now I'm talking at the subject, the adjectival level, like procedural law. So classifying into civil procedure, criminal procedure, and all of that. It is a matter of convenience. Once it is law and it fits the structure and description of law, we all know that law struggles to fit into one description. But once it has the characteristics of law and we all appreciate it as such, it's of the same importance. People have their qualms or their reservations about legal accountancy. But I have come to learn that legal accountancy equips you with some skills that if you didn't have, in practice, you'd probably be lost sitting around a boardroom and looking at financials. So everything you study really is of utmost significance. It doesn't matter the volume. Remember that we don't have credit hours here. We don't have 3 credit hour programs and like 2 credit hour courses or 1 credit hour programs. It's just the parts that you need to get out of here. If you get a 79 evidence and get a 49 in ADR, that does you no good. You're still going to have to take the paper. And it's even worse if you get 80s in evidence and criminal and civil procedure, and then you get 49s in the rest. You're going to have to repeat a year. And in my year, I had colleagues who had excellent grades in like evidence for a particular student in evidence and criminal procedure in civil procedure, and then ADR, company and commercial practice, and advocacy, LPM and accountancy, 40s. Bottom line is he had to take the whole program again because he did not pay as much attention as he should have to all the courses. So you really need to maintain a fair balance. Those of you who are good with timetables, I don't know when the exam is really, but if assuming worst case scenario, even if the exam were 2 weeks away, you still have enough time to be able to apportion study time equally among all these 6 and make sure that you execute your study agenda perfectly, right? I'll come to how to study or how I think if I had studied or how I studied to work for me or how it could have been better, however you put it. But yes, just give everything enough time because the reason you're asked to learn it in law school is because you need it in practice. In my short time at the bar, I cannot think of any of these courses that we studied in school that has not, appeared somewhere significant in my practice. And I've been at the bar for less than 2 years already. So we might have our reservations about how the courses are conducted and how they are taught and all of that. But I assure you and guarantee you that each and every one of these issues in your curriculum has a place in practice. So give them equal time and attention. Some of the courses have drafting. So I'm on point 2 now. And obviously I'm just picking next points because they resonate with, my experience. Start drafting as early as you can. Okay. So in my year, it was made very clear to us that the difference between faculty and law school really is the practical nature that the program is supposed to be rendered in. Okay. So they would expect that a lot more of the questions would be practical. So company and commercial practice, for instance, expect the practical dimensions of it, like drafting resolutions, and, drawing up minutes and all of that. Those are the things they expect you to see. In fact, know everything else, but you can't go and write an exam without, studying thoroughly the practical aspects of it. So, for instance, if you are studying, now we have 992. Back in the days when we had 179, the forms haven't changed by much, but they've changed the form slightly. So for instance, they give you a problem question and they expect you to figure out exactly how you are going to how you're going to go about the situation where the company secures lending or financing and then they secure a charge over some of the undertakings of the company. Now, there are very specific requirements at law for that. What forms you have to file with the Registrar General's Department, what resolutions, if any, assuming the company is trying to enter into what we call a major transaction now, right? You need to learn how to draft resolutions. In fact, do you need an ordinary resolution or a special resolution? So all those practical aspects, really, the fine details, you shouldn't take your eyes off that. As for the rest of everything else, like, the theory, you've already done all of these things in the faculty. So really, even if you see them in the exam, that's because the examiner assumes that will be, you should know that. But really, at this level, your exams will 10. And most of the things that get people like, I don't want to say weeping for want of a better expression. Let's go with that. After exams, really is always the fact that the exam was a little, too practical. It's never really about the fact that, it was theory. Maybe there was a time where people didn't expect, them to bring questions from like practical theory, theoretical company law, and they did, but we've since moved on. And now you have a manual that delineate exactly what you should expect to see. So pay attention to the theory, that's important, but it's taken for granted that you should know that. So really, emphasis should be placed in your study on the practical aspects of the program. Same applies to ADR. For instance, if you're trying to enforce a foreign arbitral award, if you're trying, you need to look at the act, you need to find the precedents, you need to try your hands on the drafting and try it as early as possible. If you haven't started drafting today, the best time to have started doing that would have been a minute ago or even at the beginning of the semester, right? So drafting comes to you by practice. So yes, all the courses where you see that, of course, you might be asked to draft, start civil procedure, criminal procedure. I shouldn't be telling you that by the time you write your exam, you should know exactly what the charge sheet looks like. You should know exactly what a bill of indictment looks like. Okay, you should revise your Act 29. So right from, I don't know, inchoate offenses all the way through to the substantive offenses. Mostly look at the very popular ones, because obviously you can't charge someone without knowing the offense creating section, right? So you need to know the very popular ones. For instance, when you're going to write an exam and you've done all your drafting, at the back of your mind, I remember, so in my exam, and all this live experience, we got a bill of indictment, and criminal procedure was like essentially one of the favorite things for me. So I enter into this one and I see an attempted murder question. I'm like, attempted murder. You see, so of course, a lot of people, when you look at Act 29, then there's Section 18, which is attempts, no? So usually when you charge people with attempts, it will be the inchoate and the substantive. So if it's, for instance, let's say I'm looking for a very common offense. Let's say Section 69, which is harm, right? So causing harm. So for instance, if you want to charge attempted harm or something like that, so it will be 18.2 and then the substantive offense, which is 69. But of course, there's a substantive offense for attempted murder, which is in Section 48, right? Section 48 of the Act. So you need to know that in my year, a lot of people went the 18.2 way and some people got the provision wrong. Me, for instance, I went to write Section 74 because I blanked out. So these are some of you need to go over your substantive law for criminal procedure particularly, because if the examiner is being petty, charging somebody under a wrong enactment or a wrong provision is a fatality. Because if I'm defense and you show up and this is your charge sheet and you say you're charging somebody with attempted murder and you quote Section 79, obviously that's not a non-starter. So you can't even prosecute somebody on the basis of an erroneous charge sheet. So you need to watch out for those. Revise your substantive law for criminal procedure particularly, and pay attention to drafts. Civil procedure. Recently I saw your supplementary exam. My problem with the law school is that you can't predict them. In my year, drafting was intense. And our people, they made us know that we should expect drafting. Then a year afterwards, we went back to the Mafusal style of short supplies and all of that. So really, if I'm in your position now, what I'll do is that I'll leave no stone unturned. I'll make sure that I'm on top of drafting and I go over all the past questions that do the short supply thing. That way, whichever way they decide to go, you're safe, right? So that's that. Civil procedure and evidence. Evidence is a lot, isn't it? So even though I said you should devote the same attention and time to all your courses, you should know very well that because of the volume, you probably are going to have to find a way of making sure that you cover the material without sacrificing the time for the others. That takes tact and skill, but it can be mundane if you start early, right? So make sure that for those that seem like there's just a lot of material to consume, have the time for it, have the time, make sure you read the material There's Maxwell's book. There's Justice Brobe's book. I don't know if Sir Dennis has evidence, but you can really pick and choose which one you want to use, or you can, as some of my mates did, you can like compare the books, like read from more than one textbook, handed down notes. I'm not going to say on this call that you should rely on handed down notes, and I'm not going to say that I didn't do that. Okay, but find a balance. When is nearing exam, that's not the time to be reading textbooks. You don't carry Brobe's book around a week to exam. By that time, you should have, extracted as much material as you can and, move around with your notes or, flashcards, pointers, that kind of thing. Information overload is a real thing. And so if you don't watch it, you might study thoroughly, be prepared for it, and then you enter the exam hall and then it all comes crashing down. So you need to look out for that. There are some courses that some of us did not do at the faculty. So I went to Legon as a post-first degree student. So obviously I had no interaction with ADR. Okay. The only ADR I knew was a tiny little bit of it I did in legal systems and methods. That's that. Some of the undergrads from Legon had already done ADR as a course in level 200, I think. Okay. So some people from tech had come to law school, having already done evidence. Do you get it? So you need to figure out what your deficiencies are and make sure you get the supplements so you're fairly balanced before exam. As for accounting, apart from those who probably had business backgrounds from high school and those who are professional accountants or people who have significant exposure to accounting, a lot of us were really just lost, debiting and crediting left, right, center. We're just sitting in that class. So you needed to advise yourself early enough. You need help. If you need professional help, get professional help. When you get professional help, they'll demystify accounting and you understand that it's really not rocket science, right? Once you do that, you put yourself in a position to be able to go through everything smoothly. Remember, if you're studying everything else and you have a problem that you have not taken care of, I don't know how the psychology works for you guys, but if I'm walking around with 10 things on my to-do list done and one thing not done, I know no peace. I need to clear it. I need to tick all my boxes. And if you have no peace, it's going to affect you psychologically, even in those subjects that you think that you have a firm grip on. So you need to get help with the very technical subjects, those that you're not exposed to. So ADR, if you didn't do it, get help. Accounting, definitely get help if you need it, and do that early. Somebody can just unmute. If anybody can unmute and tell me when your exam is, I'll need the context. Okay.
The exam is on 17th June to 8th July.
17th June. Oh,
yes,
that's time.
Please.
Okay, thank you. So,
Jonathan, do you say there's time?
There's time to be able to implement what I'm saying you should do. Because you'd even notice I was telling you that assuming worst case scenario, the exam is in 2 weeks. You should be able to overload yourself, but balance it fairly. So I mean, if we are looking at the 17th of June, there's still May, all of May, as a matter of fact. So that's like 4 weeks plus an additional 2. So give or take, we have like 7 or 8 weeks, no? So we have a little time to be able to put things in place before the exam. Now, let me tell you why I say you have a lot of time. Ask my colleagues, ask my mates. When I was in part 1, I hardly ever was in class, and don't ever live in law school like me. Today, I'm on main campus trying to get people to vote for me. Tomorrow, I'm in Kumasi trying to get votes. The next day, I'm back at Gimpa, and I'm not even back at Gimpa to study. I'm back at Gimpa to see if I'm gaining ground. So by the time they said Jack and it was revision week, by the time we had 4 weeks to exam, 4 weeks or so, and if I told you I knew the stuff I was going to write in the exam, I'd be lying to you. Because I had gone in and I was like, I've given this SRC campaign thing a lot of effort. And so I might as well just kill it. So I gave it my all. And then I required for like 3 weeks or so and made sure I did what I had to do. Because as I said, coming to school really was all about getting called to the bar. Everything else was corollary, right? So in those 3 weeks or so, when we get to the techniques, I'll tell you how in 3 weeks I was able to turn myself into a clueless student because I really didn't care. I was just concerned about politics. From a clueless student to a student who was able to scale all the 6. So it's really about the techniques, and about your community. We'll get to that in a bit. So yes, seek help. The technical courses, get as much help as you can. The voluminous courses, start early, give them the attention they need. And evidence, for instance, evidence sort of underpins every other thing you do in practice, okay? And even with corporate and commercial practice, there's a dimension of evidence to that. We can always talk about that later. But for criminal litigation, civil litigation, whatever other thing you're trying to do with the law, to vindicate rights or to solidify claims, you're going to need evidence. So put it where it belongs, right? As I said, we only classify for convenience, but they should also be, aware of the fact that some courses are pivotal, like civil procedure. Civil procedure is essentially like Letang and Cooper would say, for instance, if you can't figure out what your course of action is or whether it has even accrued, there's no business going to court. That's the very first step in civil procedure, right? So they are fundamentals. So give the fundamentals the required attention, but maintain a balance and treat everybody with the same respect. Do you understand? Every subject, not everybody. We'll definitely come to your questions. I saw a lot of questions, but before I start picking the questions one by one and addressing them, I can't forget to talk about study groups. Now that's exactly how my study group was made up of 5 people, right? So, and this was a study group I'd already studied with at Legon, in preparation for the entrance exam and all of that. So we had chemistry. We understood. You see, we knew who knew what. Who could do what. Who could get us the notes. Who was meticulous at writing down details we had forgotten in class. You see, there's a reason why we don't practice. We have one-man law firms, but there's a reason why law, by its nature, is supposed to be practiced from chambers where you have more than one lawyer, because the law is a communal sport. You can't practice law in isolation. Sometimes the processes speak for themselves. When you pick a process and you look at it and you see avoidable error, sometimes it's evident and you can see that it's coming from a one-man firm. Not because the lawyer is not excellent or the lawyer is not good, but because law by its nature will drain you. And by the time it drains you, you're not going to see some of the things that you've drafted, which shouldn't even be on your process. That's why you need people to run it by. I bet you can draft a process and read it 10 times and you won't catch an error, and your colleague will catch the error at the first try. That's just how it is. And that's the point of having study groups. Sometimes you're roaming around with poison and then you're going to put it on the exam script. I cannot, for the life of me, think about how you can walk through law school smoothly without a study group. Somebody can controvert this claim, but I doubt that there's anybody who can discount the essence of a study group in your legal formation. Study groups are vital. If you don't have a study group, it's not too late. Find one. There are people who join study groups for exam keke, and it worked for them. Because for me, somebody who was up and about roaming and trying to win votes and all of that, how was I supposed to know what Miss Kilson preferred on her chai sheet or how she expected us to do ABC? I needed people. I just needed to feed on the knowledge of some of my group mates who were always in class. and you need to push yourself. If I could do this in 4 weeks, everybody on this call can do it in like 7-8 weeks, honestly. So, we have time. If you don't have a steady group, find one. I can't emphasize this enough. Find a steady group. Don't find a steady group because they are friends. You see, there are people that I can jam with. So there are people that if we forgo Bloom, if we are supposed to like go to Bloom Bar or Garage or somewhere, those are my guys. That's the squad, because that's where the vibe is. That's where the chemistry is. But I'm not going to go and sit in a group discussion with them, not because they are not worth my time, but because that's just not the combination. They would also find their level in some other steady groups. So some of my friends who, like we can jam together. Jamming is one different thing. But I will not join a steady group because I think that we already have quite a formidable friendship. So we should be able to work together. Particularly if you look at it and you realize that the two of you don't complement each other in any way academically. There's no point being in a steady group. The whole point of being in a group is to be able to draw on each other's strengths. So pick a steady group and pick it wisely. Don't be drawn to steady group simply because of affinity or because of friendship. In fact, familiar relationships are the last thing you should consider in choosing a steady group. Yeah, so I think I was supposed to have told you things I wish I knew. And I think I've done that to an extent, but I've also told you things, fortunately, I found out, which I was able to deploy to scale the first 6. So, Saki, is it okay to just delve into that? Because there are so many questions. I think we should go right into them and pick them, as many of them as we can answer.
Yes, let's go into the questions. I think we can start with some of the questions we got from our Google form, and then
that's what I mean. So you can. Do you want to read the questions one by one, and I take them? Is that what you want to do? So do the charade. Pick the questions. Because the
okay. Yeah. But before that, I just want to mention that so we had quite a number of respondents, and 43.6% of them were telling us that accounting was the course they are least comfortable with. 43.6%. You also have 21.8% of the respondents telling us that company and commercial practice is the course they are least comfortable with. And then 16.4% were saying that law of evidence was the course they were least comfortable with. So top 3, accounting, company and commercial practice, and then law of evidence. So Jonathan, is that some good context?
Yeah, that's good context. But before we go into the question, somebody says talk about study techniques. Let me just do that before we go. Yeah, so studying at the faculty was slightly different from studying at law school for me. As I said already, I had limited time to prepare for exams. So my method might have been crunch. It's just like I just threw everything at myself and tried to drown in it and found a way to stay afloat. But really, what I found in the aftermath of the exam is that I haven't fought all this while to get them to give us course manuals. There's a reason why now we have those course manuals. Company and commercial practice, for instance, I'll use that as an example. CCP had quite a discouraging pass rate in my year. But the thing that worked for me and for everybody in my study group was that we made sure that we left no stone unturned in the manual. That manual looks very scanty, but it had a lot of information. You see, it was skeletal. You needed to flesh it out. So from page 1 to the very last page of the manual, you need to make sure that you've covered everything. Look, it's okay if you have notes and all of that. You can read the notes, but I dare say that the notes, as bulky as they might seem, are only supplemental to the manual, because the manual really, you know how Dam and Ado and Hammond and Odoe will tell you that pleadings are the nucleus around which you build your case, and so they rule against departure and all of that. Essentially, look at the manual as the way that the managers of the school have decided to put forward the case for study. so that now as we have it, it's going to be very hard for you can't trust IEC. Don't quote me anywhere. But it's going to be very hard for them to go outside of that manual. So every time you go to study, make sure you have your manual with you. You know, if it's CCP you're studying, whatever it is, the trial questions, evidence, for instance, look, evidence in my year, 70% or more of the questions were just lifted from the trial, the questions in the manual. You know, if you had gone over those questions in class with your study group, that paper would have been a walk in the park. Do you get it? So read as much as you can, but you need to read with direction. And that direction can only be afforded with the manual. I think I can, dovetail this submission into the fact that people are uncomfortable with accounting and evidence and company and commercial practice. Look, in my year, company and commercial practice was a problem. A problem because, I want to sound very politically correct, I'll rephrase. Company and commercial practice was hard. Okay, because for most of those who had problems with it, it was the instruction, the mode of instruction. It made it a little abstract. But the good thing was that we had excellent notes. Kimathi gave us excellent notes. So I kind of feel like for the flaws in instruction, he made up for those flaws in the excellent notes that he gave us. So I didn't really have a problem with CCP because then I stuck to the notes, stuck to the manual, and really that's how I passed company and commercial practice. I'm not saying, I don't even know that there's any textbook on CCP now, okay? So really, just make sure that no matter what you do in all the programs, make the manual your Bible and study strictly in conformity with it. Study extra material, of course, when you have the time, but you cannot attempt to go and write an exam when you haven't covered the manual at least twice. For accounting, I've already said, look, accounting can be very easy if it's demystified by the professionals. If you're not getting it in class, get professional help. We have 7 or 8 weeks. The last thing you would want is to, because if you don't pass accounting on the first try, in fact, if you don't pass any paper on the first try, chances are that it will be very difficult for you to pass it subsequently. That's just how it is. So give your first try your best effort. Find professional help. There are people who do classes. If you have an accountant in your family, the accounting we do in law school is very elementary, right? So just move to them and let them help you with the basics and pay attention to the theory of accounting. Thing is, they've also realized that students are not too comfortable with the numbers. So they do as much as they can to balance the questions. In my year, there was a fair balance of theory and the practical parts. So don't take the theory parts of accounting for granted. As a matter of fact, that is what you should make sure that you have a firm grasp over, because right now, your problem is not reading and understanding. Your problem is understanding the technicalities of accounting, at a practical level. So make sure that for what you can at least read and understand, you know it all. And then get professional help for the rest of it. LPM, they mark those together, give it the seriousness that it deserves. ADR. In my year, more than 50% of students failed ADR at the first attempt. And if you see our ADR paper, it will shock you that anybody could fail that paper. Why? Because the reasons I put forward for the abysmal performance in ADR in my year would be: one, people took the course for granted. Like I told you, it looks straightforward. It's not just principled negotiation. It's not the ADR Act and getting to yes. What else? It looks very down to earth. But apparently it's a very technical subject. So make sure that, you give it as much attention as you can. Try and read all the material on your study material and the manual again. Make sure that everything that's provided in there. For instance, if you're answering a question And in the manual, they've given you indicators. Make sure you don't leave anything else. Just give them everything that they want, because that's what they are looking for. They are very specific. In part 2, when you get to advocacy and legal ethics, they'll tell you that for that course also, if they ask you for qualities of a good advocate and you're going to mention, say, presence, and you don't define presence in the exact words, I'm not saying we're true and poor, but practically that's all they expect you to do. Make sure that you know what they want and give it to them. So yeah, study techniques. I don't know what else to say apart from the fact that study in groups. Make sure you discuss what you've studied. Sometimes you think you have it. You think you've mastered the material until you have thought-provoking discussions with your group mates, and then it all makes more sense to you. So that's the manual, getting help, starting ahead of time, past questions. I don't know anywhere in the law school that I saw in my years, just 2 years actually, but in my time in the law school, I didn't see any question that I hadn't seen in past questions, So make sure you have them. People have past questions from day one. It was a technique from Legon, people start solving those past questions from Legon. It's not a waste of time. You can't do that alone. But of course, that's important. Why? Because you're going to go and meet those problem questions in the exam. So the more you are familiar with, cracking these problems, even casually, the better for you when it comes to exam conditions. Nobody is saying that chew and go and regurgitate on the exam paper, but at least go through the past questions and have a fair idea of what they expect. Last thing on study techniques, me, for one, I never trusted marking schemes. You know why? Because of some of those marking schemes that make rounds and look like they are from IEC, some of them are manifestly wrong. You just look at them and they don't make sense. And people used to be so religious about some of those marking schemes. And I'm like, you know what? I'll pass. Everything I need to pass the course is in the manual. I'll see the past questions, I'll see the manual, and I'll know what the answer should be. You go and see an IEC marking scheme that will throw you off guard and probably destabilize you. I remember in our part 2, there was this interpretation question. I bet you on any day, if you wake me up from sleep and give me that answer and tell me that answer was sanctioned by the Chief Justice, it will still be a wrong answer because it's wrong. But that was a marking scheme, apparently making rounds as the right answer to a question. Now you can't verify if that marking scheme indeed emanates from the IEC as they claim. So don't religiously rely on schemes that make rounds. If you have a firm grip on the substance and you've seen the questions and you understand how the working should be, you should be fine. Just look at these marking schemes. If they make sense, you will know. If they don't make sense, you will know. Not everything out there should be swallowed hook, line, and sinker. Yeah, Saki.
Jonathan, so I went through all the questions we got, and there's this one that caught my eye. The person is asking, what advice do you have for students who feel overwhelmed by the amount?
Saki, did you say what?
Yes.
You're breaking up.
Sorry. What advice do you have for students who are feeling overwhelmed by the amount of material to study?
You see, exactly what I said in the beginning of all of this. You can't study when you're stressed. You can't study when you're not in a good state of mind emotionally. So you see, information overload is a real thing. If you're overwhelmed, find some activity to distress. You see, it never gets better, honestly, because there's always a lot of material. But if you start out early and structure your study properly, you don't have to go through the pressure some of us, in 3 weeks, you're trying to prepare for exam. That's madness, right? If you start ahead of time and have it all sorted out, what sometimes gives you so much pressure is proximity. So if it's 3-4 weeks away from you, you begin to panic. And that affects the amount of substance you can, assimilate and all of that. So really, if you feel like you're overwhelmed, there's no reason to continue to push your brain. Find some activity. Somebody saw me, like, I think it was a day before civil procedure or something. I went to play basketball at Legon because we all moved to campus. I was a parent. And the guy was shocked. He's like, but you have a paper the next day. You're going to play basketball. Yeah, that's what works for me. At that point, if I don't go and play basketball or find something fun to do, the next day I probably won't be able to write the paper. So I attach utmost importance like mental health, because if you're overwhelmed, that could lead to a breakdown. Take your foot off the gas pedal. The law is not meant to kill you. It's meant to make you a better person and turn you into a useful person for society, right? So if you're overwhelmed, find something that relaxes you, come back and try and take it bit by bit. But what you shouldn't do is do not fall victim to the proximity virus, because no matter what you do, if you are studying fresh 2-3 weeks to the exam, I really have no remedy. You're going to be overwhelmed the entire time, and that's no good. So you have 7 or 8 weeks, as I've said, space it out. If you're going to draw a timetable, like, I did, like, 3 weeks, I split the 3 weeks equally. So 3 weeks would be 21 days, no? So 7 days, I try and do 3-4. So in a week, 3 days for one subject, 4 days for another. 3 days for one subject, 4 days for another. I try and finish as much as I can. The next 2 weeks, I reduce the time, like 2, 3, and I go over. That's what I did in part 2, because in part 1, I told you in part 1, I had only 4 weeks for exam to even study the whole thing and like go and write exam. So that's the way to go about it. Make sure you cover all ground, have time to revise it before you enter the exam. If you're overwhelmed, my brother, my sister, take your foot off the accelerator pedal, find some rest, relax, and come back to it. As they say, you can't come and kill yourself.
All right, Jonathan, there are also a lot of questions pertaining to civil procedure. And so I just want to put it into one. How do we navigate civil procedure?
As I was saying earlier, in my year, for instance, we had a fair indication. The reason why more than 50% of my year group failed civil procedure at the first try was because it was full of drafting. You can go and draft a whole statement of claim. Forget statement of claim. That's even so. You can go and draft the whole application, right? So, for instance, maybe you're drafting an application for leave to file a statement of defense out of time, and you do the whole motion paper, the supporting affidavit. You do all of that for like 4 marks. So they were like those draft things. Like you have to. So my civil procedure paper. When I saw the paper, I knew the instant I opened it, I was not going to finish. So I left out 2 drafts. I didn't do them because those 2 drafts were like 4 and like 5 marks. I decided from now, I won't finish this paper. I'll go for my above 50 and I'll do what I can do. So you need to look at the paper. Like when you enter and you see drafting like that, there's no way you're going to draft an application, the motion paper, and the supporting affidavit. There's no way you're going to do that in like 15-20 minutes. So if the marks allotted to such a draft is like 5 marks, you're better off going somewhere else and doing something else that will fetch you more marks, even if that ultimately means skipping that question and not doing it. So yeah, you need to balance it. But if it's like the Mafusal type of question, when you see those questions, they would ask you, for instance, what do you do when somebody files a writ of summons and the person is ordinarily resident outside Ghana but does not endorse that fact on the face of the writ? Of course, you know what to do because it's in the rules. So you go straight ahead and say, on the authority of Standard Offshore Trust, blah, blah, blah. And then, just this is what the law says, or that this or that. Straightforward. When you see those questions, But I saw your, Lord bless his soul, Justice Mafusal is not around. So his type of questions might not make their way into your exam anymore. our type of drafting, they advised themselves because it was just too hectic. People will not finish and they'll fail. So I think now it's a balance. When I saw the supplementary paper and a lot of people complaining about it, I kind of understood why they were complaining, because I'm like, what is this? You need to pay attention to it, because some of your mates had previously, I think earlier, some people had consulted me about some of those questions that the man had come to talk about in class or something. So you need to pay attention also to some of the contentious questions that they give you as take-home assignments and all of that, and try and get to the bottom of them. But the bottom line is, if it's about drafting, make sure that you draft and you leave the technical language in there for them. Don't quote me anywhere, but I've come to realize that our educational system, the problem with this is that they expect you to regurgitate the technical language. So if you are drafting a general traverse, the general traverse cannot be in your own words. You need to go the same way you see save hearing after as expressly denied. The defender denies every statement of fact. You put it there the exact way, the exact way you see it in the drafts. That's what they want to see. Or when they see it like that, of course, mark it 2 months. This is a serious student, But really, that's archaic language. But that's the language that we use in court. So you need to, for the drafts, I beg you need to cram the language. I don't know if they'll still ask people to draft motion papers. Those things are standard forms. But of course, if they ask you to draft an application, you're going to have to draft the motion paper to show the language there. You have to stick to the technical language and don't leave anything out. So yeah, for drafting, the technicalities, and look out for the finest details. They might throw you a question. For instance, put in a claim of fraud, and then you're supposed to draft a statement of claim, and then you're supposed to one of the averments is supposed to plead fraud, and then you plead a fraud and you don't particularize it. That's just fatal, because clearly when you see that, you should know what the examiner is looking for. He's looking to just trap students. They won't particularize, and he's like, ha ha ha, I got you. So the minutest details are what you're looking out for. It just those areas of the law where they create slight exceptions. Yeah, so ordinarily you will not have to particularize, right? But if it's customary law, you plead facts, not law. But if it's a rule of customary law and you're trying to establish that you're pleading, yeah.
Losing you. Okay. We're losing you a bit.
You are losing me.
Yes.
Yeah. Bottom line, I'm like, just stick to the technical language for the drafts. And for the short supply, don't go and write essays. If they're asking you, what do you do when a defendant files a writ without endorsing the address when he's resident outside the country? Just, you know what to do. Just go for it. Go for the jugular and give them the authority and move. Also, take a cue from the marks. As I did, and I never regretted it, I skipped 2 drafts because I was never going to draft the whole process for 5 marks. The whole application and the supporting affidavit. I wouldn't have done that, not for all the rights in China. So if you have to skip, and as Maxwell normally says, it's a 13-12, right? There's no point getting a 22 on one question and then getting 3-2-1. You're still going to fail. And somebody with a 51 is going to pass the paper to your detriment. So do the calculation as you're writing the paper. If you see that, Charlie, you've done enough to earn you some marks here, but you need to finish the paper because the other marks are worthy of, attaining, go for it. I hope I've made sense with that.
Yes, you have. There's also another particular generic question that keeps running through the specific questions that we got. And I think that it also relates to some of the conversations some of us may have had with people who who supposedly failed the last part 1 exam. What exactly are the examiners looking for? Because you talk to people and they say, I don't believe I failed. They seem to be of the opinion that they actually did the appropriate thing, they did the right thing. What exactly are the examiners looking out for?
When I was looking at the questions, I saw one of the questions that said, what caused you to fail part 1? And I shook my head. I'm like, why are you assuming this? But you see, I won't be able to tell you what exams are looking for. Honestly, you see, even so, I passed all 6, right, to the glory of God the first time. But even then, when I went to look at my raw score, I kind of felt like for some of the subjects, I needed to have like hit higher marks. Do you get it? And, and the remarking lends credence to these thoughts because I can name countless individuals who like failed the paper, went for remarking, and then they passed it on the remark, right? So I think it's a function of the subjective nature of the assessment. Here's why I say that. IEC is amorphous. So we don't have fixed examiners. It's not, now they are beginning to draw on the industry of some of the lecturers, but the scripts really go far and wide. I know practitioners in practice who mark scripts. So I don't know if they still do that. So imagine that, Saki, you and I write the same civil procedure exam. And of course, there's supposed to be a marking scheme, as they would say, but Saki, your script goes to somebody at XYZ firm, and my script goes to somebody at WBI firm. I don't remember the initials, but 2 separate firms. 2 separate lawyers, separate temperaments. Some have, some are sticklers for some are just, like, okay, I see the effort. They say if we swap the papers, you might have scored 15/25 on a draft. If we swapped your paper and gave it to the other practitioner for the other firm, you could have easily scored like a 10, depending on how stern, for want of a better word, really, the examiner is. It's very subjective, that's the thing. So, you see, what I would advise is that this law school exam, give it your best shot. See, even if they are going to fault you, let it be to the point where they don't give you an A, right? So I know a lot of people, and then again, it's difficult to say you are doing 13-12, and aim at 80. But if you aim at 80, it's really, really hard to fall from 80 to 49. But if you set out wanting a 50, with the subjective nature that, your exam scripts are assessed, chances are that your script might land with somebody. And the difference sometimes is just 1 mark, like 49. And that 49 could have been 50 or 52 with another examiner, right? So go for it. Go for the 80. There's no reason why you shouldn't go for the 80. If the 80 doesn't come, at least you can manage a 59 or a 60 or something. If you know what I mean. But yeah, to answer your question directly, really, you can't tell what those guys are looking for. What your job, if you ask me, if anybody asks me today that, what do you think you did to pass all 6? I wrote what I thought I needed to have written, right? I studied what I should have studied. But as for how I was able to scale the 6, I'll just say that, that's what I expected. But I really don't know what went into the process. And I can't guarantee that if they have flipped my scripts, and I'm being very honest, I can't guarantee that if my scripts had gone to some other examiner, I would have had the same marks. So just do your best. And so that at the end of the day, because there are some people, when the results come, for instance, if my results had come and somebody they had said maybe had failed some criminal procedure, I would have gone for remarking. I would have followed that script because sometimes the industry you put in the exam and you know what you put on the script. Some people don't even go because they know what they wrote. Do you get it? So do your best and hope that the system doesn't screw you. If the system screws you, hope and pray that remarking comes to your rescue. But what you can't afford is not to do your best. Because what I always say is that as far as I'm in charge of some part of the process, I'll do my part. The rest of it, that's out of my hands. I'll pray that nobody jeopardizes my aspirations.
So I think I'm getting quite a number of messages on my phone. People are excited to hear you say that 22nd of April till June is enough time.
Oh, it is.
They are. A lot of giving them a lot of hope.
I'm saying it on authority because if you ask my study mates, my study group was made up of Eubank, Courtney, Daniel, myself, who else? Kojo. Yeah, they'll tell you. I had no idea what was happening in school. I was doing politics. I used 4 weeks, and that's not to say that I possess some extraordinary mental prowess. It's to say that I just, I'm like, you guys, Charlie, drag me along. This study group thing, I need it. And I took the manuals and I studied them religiously. So yeah, that's that.
Okay. So at this point, I would want to invite questions in the chat box on Zoom and also on YouTube. You have a question, you can put it out there to unmute themselves and ask question, but then ask your question. We're doing our best to wrap up before to wrap up by 8:30 or 8:40. Let us do 8:40. Yeah. So please keep your questions coming. I see a question. Someone says, if I cannot remember a provision of a statute or case law, how do I state a legal principle? And I mean, there have been several rumors. Oh, this professional program is not hell-bent on stating cases and sections and all that. We just want to know how much you know, how much of the law you know. I mean, are these true? And I mean, specifically this question, how do you go about stating something you've probably forgotten the nomenclature of the case or the statute?
Yeah.
Jonathan, are you with me?
Yeah, I'm with you. So just before, I probably forgot to say, presenting your answer, right? And this again, I learned the hard way. I prepared, in a short time for part 1 exams, and of course it was good. But I realized from my part 2, if you look at my transcripts and you look at my part 1 grades and you look at my part 2 grades, you would be able to tell that in part 2 we didn't come to play, but in part 1 we came to pass and move. And that's because I kind of realized that even though I presented the material the way I should have presented it, I probably would have had higher marks in part 1 in all the 6 if I had presented the material in a particular way. So IRAC is a big deal. I know from the faculty, IRAC was like, the anthem and, we all sang it and all of that. But for instance, evidence, they still really expect you to lay down the law. For those of you who went to Legon, Mensa Bonsu style. So you do not just raise an issue and address it. When you raise the issue, give us a relevant rule, right? That's where you talk. If it's a question about traditional evidence, for instance, they expect you to start. And you see, that doesn't hurt you. I've come to realize that, look, if the examiner doesn't even want that, the best he can do is to cross that part out and mark the rest. But if you meet an examiner who is bent on seeing the background, the substance of the law before you sort of narrow it down to your issue, then you have a problem. So make sure that you strictly comply with IRAC. And when it comes to laying down the rule of law, be very meticulous about it. So that, for instance, if the question, as I said, is about ill-gotten, right? If it's about ill-gotten evidence, and obviously you're going to have to start laying down the law about admissibility and exclusionary discretion of the court, and and all of that, and the balancing, lay it down and then pick it and apply it based on the facts. You might have a slightly bulky script, but nobody will throw out such a script. Worst case scenario, they might just skim through the rest and go to the relevant portions of it. I hope I've made sense with that.
Yeah, Jonathan, you made sense with that. Kindly keep your questions coming in. I'm trying my best to juggle between YouTube and Zoom. And some of you are also sending me private messages. Okay, you can, in the general box so that everybody can see it. And for a lot of you, I mean, Jonathan was strategically chosen because he's seen a lot of things. He was involved in quite a lot in school, so he has a very good understanding of how to strike the balance. You heard him talk about the fact that he was, doing quite a number of things, including running an election, and yet still, when it came to it, he had to put in the effort. We were winners, but then we're like, maybe they were staying a lot, but I think this is balanced information for most of the people who are working, even though we are not supposed to work. That all is not lost yet. It's completely not lost. And if you are feeling overwhelmed, just take a short break and then get back to it. And I think I've heard several times Jonathan mentioned that the manual is very important. The manual is really, really important. But Jonathan, let's go back to ADR, because a lot of them, for most classrooms, you'd kind of find them pretty empty, when it's time for discourse. At least for ADR, the numbers, we're getting into arbitration and things, and so yes. But then for ADR and LPM, it looks like people feel like it's relatable and all that. What would you have done better? Or what would you do better with ADR and LPM?
I probably would have still skipped those classes. But you see, the thing is, no, don't take that from me. I wasn't serious. You see, that's exactly the attitude I was talking about. That you think that, these are relatable subjects, these are easy. So I won't show up. But you see, LPM, for instance, I passed that thing. Sorry, I passed LPM because my study mates were very particular, with the thing and showing up even when DOD had to come, as David Ofosudo, they had to come and teach some subjects and drop some hints. You need to be there, because you see, that course, for instance, it's his baby, right? So when Danielle or DOD or Isabel or whoever teaches it nowadays, when they're coming around, as boring as it might be, you need to sit in there, which is the problem some people had with company and commercial practice. But our friends from main campus had it. It was a walk in the park for them, and this was the part that also helped me. You see, me, I'll leave my school and then I'll go and be campaigning on main campus. And so sometimes I have to sit in their company and commercial practice class. People were tired. They said the class was boring. Trakwa is boring, The guy will give them presentations every now and then. And he'll give subtle hints, about questions and stuff like that. Look, in the exam, everything that man says comes. Everything he says comes. So you need to pay attention to some of those things. Fine, a lecturer might be boring, but he might just be your key to an A. So it's cool, really. It's not a cinema. It's not a video game. It's not a TV room. It's not about a pub or something. You're not supposed to fine. You're supposed to enjoy the experience, but you're not there to have fun. If you asked me to go and have fun, I will not be having fun in an office or in a classroom. But those are things that have to be done. You have to sit through it. Because if you don't, there's a tendency to take it for granted, and that's the beginning of your downfall. Because I kid you not, ADR, it was so shocking. Over 50% of my year group failed ADR, and it wasn't even a complex paper. So yeah, that's that. You guys should, show up for the classes, give it the seriousness it deserves, because obviously that will rub off on your presentation in the exam.
I need to stay on company and commercial practice for me, because UPSA, which is quite a very large group, we've got about 300 students in each group, A and B, so that's about 600. It's being handled by Mr. Trakwa, who is like the Ofosudo of the course. It's his baby also, and like you mentioned, everything he says is an examinable matter. Give us some more insight into company and commercial practice, because again, you have that's the second course that people say they are least comfortable with. As for the accounting, I think the best thing is to seek some professional assistance of some sort, or join the group discussion. Also pay attention in the class. But company and commercial practice, which people say they have quite a challenge with.
Yeah, so as I said at the beginning of this, company and commercial practice, when you look at the manual, you realize that there are very specific things they are looking for, right? So if it's mechanics of incorporation, it's mechanics of incorporation, the cases they are looking for, the practical things they expect you to do. For instance, if they expect you to incorporate, which forms are you using? What's the process? GIPC requirements. You see, the manual is a very powerful tool, which is what I'm saying. In my year group also, same thing, company and commercial practice. What animal is this, But when you pick the manual and make sure that you stick to the manual and, you cover it back to back, you realize that, look, company and commercial practice cannot be taught in the classroom. But for the purpose of exams, you will be fine. Because commercial practice is like boundless, right? Company law itself, it's a bulky act, maybe. But the synthesis of company and commercial practice really, as it pans out in practices, it's not something you learn in school. But these foundations, exactly. So the course about foundations, which is why the manual might seem scanty. But those are the things that they expect to propel you. So you need to stick to the manual and make sure that, look, even if you don't know anything at all, you should understand the manual, know it perfectly inside out, know everything inside the manual, and then expand your knowledge on that. That really is the way. We had notes. I don't know if those notes still make round, but I always give credits where credit is due. Kimathi's notes were excellent. They should still be excellent and useful, except that you might have to read the notes with significant modifications because of Act 992. Because at the time, or maybe they've even updated the notes, because at the time that we were around, was still 179. So we used no provisions of the Act. So yeah, that's just the manual. I can't overemphasize this. There are people who use only a manual. Make sure that where the manual, they understand they get all the provisions, look the provisions up in the Act, get all the cases, read the cases, and that alone earns them the 50 plus that they need to pass the exam. Because really, it is a manual. It guides you on exactly what the examiner would expect.
Great. So I think I've had some conversation with people where this manual matter has been stressed, and I think for most of you joining us, if you just assume that the manual is some simple guide, I think we are learning today that the manual is actually the Bible. So try and make sure that you consume the manual and then flesh it out with the other information that you can get. Abdul J is asking, Jonathan, I think you mentioned that criminal procedure was your 40. Please, can Jonathan clarify the minimum number of counts one should scale in a drafting? That is the charge sheet and the bill of indictment.
It depends on the facts, right? So each count simply means a distinct offense as against an object of offense. So if it's, let me give you a fact situation. Say Saki and, I'm just going to pick a random name. Saki and Adepa, right? Saki and Adepa ransack my house and steal my television set in my hall. And then they go into my bedroom and sort of, uproot my AC from the wall.
Jonathan, I think you need to adjust your microphone. Your voice is pretty low.
Saki and Adepa come to my house, ransack my house, pick my TV in the hall, and enter my bedroom, unscrew my AC, look in my wardrobe and pick my jewelry. And maybe on their way out, my Apple Watch is on my table and they pick it as well, right? Remember, what is stealing, really? Dishonest appropriation of a thing that you do not own, right? So, with respect to the television set, the fact that the appropriation was dishonest and that it doesn't belong to them, and it's a thing of value, whether 1 cedi or 10 pesos or whatever, that is a count of stealing. With respect to my watch that they picked, that's another count. The jewelry in my room is another count, and the ACD on screen is another count. So it really depends on the facts. Does that make sense? So even though it's the same stealing activity, there are separate counts that came out of the same activity, and I'm ignoring the inchoate part. So I'm doing only the substantive. So for the stealing, even though they came here to come and steal proper, the counts are different. So if you are stealing government money, for instance, and let's not say stealing, you willfully cause financial loss to the state under 139A, right, of Act 29. So let's say that's what you've done. You are the managing director of, say, Smith.
Jonathan, your microphone is still a bit low. It keeps adjusting,
But did you get my first example?
Yes, I got the first example. But you sound now. I don't know what is creating the variation in your voice.
Yeah, I was just saying that, for instance, under 139A special offenses, right? And willfully causing financial loss to the state. 179, not 139. And say you're MD of TOR and you enter into some contract that you should have known better about, and it causes loss of like 20,000 cedis. And, that 20,000 cedis was supposedly guaranteed, on company assets. And as a result, you lose money. And in an event to say salvage the situation, you recklessly sell off company assets. And at the end of the day, we all come and we see that your conduct, like if it's a continuum, the whole conduct caused financial loss to the state by a willful act. But when we look at the counts, we realize that one isolated event of, say, entering into a contract cost the state this amount of money. The other act of, selling off this assets of the company cost us this amount of money. So you should look at it that way. When you pick an offense and define it, there's usually separating the offense into the physical and mental components, right? Take the mental component aside. Look at the physical component. With each object that the physical component attaches to, that's the count. Does that make sense?
It does.
Yeah.
Okay. And I think this is very good information. But also, I'm sure the criminal procedure lectures are also, I think also giving indications of what they will be expecting. So just like you've been mentioning, people should pay attention to what they are hearing in the classrooms, and I think this information is also good. Nene B is asking, Joe, how can I deal with anxiety, especially picking a book to read only to realize there's much for you to do? How do you deal with that? I think we've dealt with that issue already. And Ya is asking, how do we know the exact processes and motions to draft from a given passage?
It's a tricky one. The thing is, you will really be confused if you've not familiarized yourself with the rules properly. So, for instance, you need to understand that really comes with reading a lot and understanding. So, if you enter the exam hall and, for instance, they're like, trying to find an example. Okay, great. So you've been served with a writ, and in the writ, the person is claiming that your brother, owes him an amount of money which he hasn't paid yet, and blah blah blah. And because he cannot find your brother, he has chosen to sue you because you guys are related. So he should be able to claim. and they ask you to draft the appropriate process upon receiving that. Even in practice, when you receive that, there's more than one thing you can do. Somebody can enter conditional appearance and eventually move to dismiss the matter and say that it discloses no cause of action under 11, 18, no? Yeah, or the 11 rule 18 thereabout. So somebody can do that. Another person can come under misjoinder under order 4, no, and say that, you know, I'm not a necessary party. So if you've sued me with some other people, just extricate me from this suit. But in the case where only one person has been sued, it won't make sense that you are going for misjoinder, because misjoinder would technically mean that there's no party to the writ anymore. So sometimes too, it's a blend of common sense. If they sued you as the brother and some other person, you can go on a motion on notice and, ask for misjoinder and say that you are not a proper or necessary party. So they should strike you off. But in the case where you're the only person on the face of the writ, that writ is a nullity, because remember Letang and Cooper, a set of facts which, if proved, were entitled to a legal remedy against somebody. And on the face of the writ, you are claiming something against party B, so you are disclosing no reasonable cause of action against the person you sued. So if I met an exam question like that, even though there are two apparent procedures that you can take to effectuate your rights, one seems more reasonable and, as a matter of fact, less problematic. Makes sense? So it's a judgment call. Mostly you'll be confused, but you need to make a judgment call, because the rules are there. There are only very limited situations where it's very clear. Like, for instance, they say that somebody has applied for LA and you are interested in the administration of the estate, but you are not satisfied that they'll be able to defend sufficiently your interests. That is clear under Order 66. What you have to do, you have to caveat. So that is different. But where it's a situation where there's one or more, you need to really and see it out with common sense, the most appropriate process. Because if you come to me with a process that's problematic, of course, and that's what trust is. So you need to know, bottom line is, you need to understand the rules to be able to know what process you are required to draft. So at the time of writing the exam, honestly, from order 1 all the way to the last order, you should have it on your fingertips. For instance, there's no reason why, if you go and see a fact situation where they say you and your friends own a business and, there's money coming to the business every month, but now your friends are deciding to divert the funds and cutting you out of the business, and you're afraid that by the time you finish suing them in court, they would have dissipated the funds. Obviously, you know what to do under Order 25 Rule 2, but you can't figure that out if you haven't read the rules. So it really boils down to mastery of the rules.
Jonathan, it's hard to believe that you used, the 4 weeks you are talking about to prepare for these things. I like to believe, it's all the things you are mentioning as a result of practice and time. Because, but I think we can be wrapping up now. I want to say thank you so much. I know some people kept joining in and moving out and all that. In 2 minutes, how do I make it to part 2?
Part 2, dear, you guys, I decree and declare by the power of the Holy Spirit that you all cross over. But yeah, it's not easy. Yeah, that's just a prayer. But really, you need to meet that with action. So as I said, you have 7-8 weeks. Make sure that in these 7 or 8 weeks, the first 3 weeks, split it evenly. It's 21 days, so it might not be even. So depending on the volume of material, it could be 4-3 for the first week. For the first 3 weeks, make sure that You go over all the material. See, all the manuals. Make sure you cover the manuals. I'm not just saying read manuals alone. No, that's not what I'm saying. Look at the manuals and see what they're asking you to like know and read that. So that's what I mean. So that when you pick the manual, you know that, yes, I've read this. I know this. I know that. Okay. Do that for the first 3 weeks. The next 2 weeks, really, use those ones. Now, from 4-3, you can reduce it to 2-3 and go over the material. Because you have close to 8 weeks. There's no reason why you shouldn't be able to go over the material twice before exam and go over the material. But while you are at it, make sure that your study groups are functional, because that's where, the law comes to you in very innovative ways. Sometimes you might even wow the examiner by writing something you and your friends came up with at group study that the examiner didn't even think about. You can make all those submissions on paper if you understand the basics. So yeah, stick to the basics. Nothing complex. If you know you don't know, it's just stick to the basics. Don't make it complex. And then also, as I said, pay attention to those subjects that you think are easy. Those are the ones that can hurt you. And finally, the 13-12 thing is real, okay? It worked for me in civil procedure. I didn't do 13-12, but I was never going to draft a whole process for 5 marks. I skipped it because I had to finish the others and pass my paper. If you're ever in any such position in an exam and you think that you're going to waste time chasing little marks, go for the huge marks first and come back to the little marks. Please, that will help you. And then, what was I about to say? And then the last thing is just relax. Don't stress. I mean, I understand there's a lot of pressure on your shoulders. Honestly, the law school is the one place where I was just so emotionally, like I was psychologically drained, but there's a better way of going about it, relax. If you don't play sports, find something, go to the movie. Some people like just rest it out a day or two, reset, and then connect and then carry on. I strongly believe that if you guys are in part 1 now, you have all that it takes to scale through to part 2. So I wish you all the very best. And I wish I could, offer more, but we are running against time. So it is what it is. But I'm pretty sure you guys will scale part 1, scale part 2, and we'll meet at the bar in less than 2 years.
Thank you. Thank you so much, Jonathan. I think a couple of questions are coming, but you've tackled them in mission. And I heard you talk about reading the manuals, going over the materials, join functional study groups, and also the fact that the subjects you believe are easy are the ones that can hurt you, and also the 13-12 rule, and also try and relax, don't stress yourself, try and break your tasks, into small bits, take a break, and then make sure that, you have the rest that you need. Rest yourself. I mean, it's already stressful, but then make sure that you find a way to de-stress. And I think everybody is very much grateful for the insights that you have shared. Ladies and gentlemen, thank you very much for joining. And we have been talking to Jonathan Alua. He's a former SRC president of the Ghana School of Law. And he posted something funny on his status with regards to this, but I'm not going to talk about it. And he's a very legal practitioner, superb, and wonderful gentleman by all standards. We are recording this session. It's also live on YouTube, and we'll save it up there also, and then we'll pass the link around. But thank you so much for joining. I'm sure some of you already have my contacts. Feel free to get in touch. I'll be very, very excited to reach out to you. If there are any questions that you want me to send to Jonathan subsequently, I'll be very excited to also do that. Thank you so much for joining. I don't take your presence and your participation for granted, and have a wonderful evening. So thank you so much, Jonathan, once again. And I think we can end the session here. Have a wonderful evening, guys.